If you have any technical difficulties, please let us know. And I would like to ask any other persons interesting now to register, because we would like to start with the presentations very, very soon. Thank you very much. Oh, I see we have even a participant from Japan, which is great. Hello. London also, so our seminar will be attended in many parts of the world. From Germany also, I see. I suggest to wait a little bit, because we currently have registered approximately 70 participants. Currently we are 30. I would like to give a bit more time for registration, and in a couple of minutes we will start. Oh, Denmark as well. Moscow. Tashkent. Dresden. Great, really great. We very much appreciate that. So we have now 42 participants registered. I suggest some more minutes. We have a participant from Italy now showing up. Great to see you. I get also some recommendations from the videographer, which I think I will follow. Maybe not now, but maybe the next time. Thank you very much in any event for the recommendations. So many participants from Italy. Further participants from Italy, further from Moscow. Ukraine, St. Petersburg, very, very great. We very much appreciate that. So we have now reached nearly 50 participants in the seminar, and I think it's now time to start. On behalf of Schneider Group, again, I would like to welcome you to our seminar on force majeure. We are not only covering Russia, but because of Russia, of course, we're not an important part. By our seminar, we are also covering Armenia, Ukraine, Kazakhstan, and Belarus. And so I think that we can give you a nice overview on what force majeure means in the relevant jurisdictions, and what in particular force majeure means in the time of the coronavirus. If you think that the coronavirus means we have force majeure and you can delay all your deliveries, I must have to say you are wrong. You are wrong. Not only in Russia, you're wrong in all jurisdictions. Force majeure will be treated in all jurisdictions as something very special, and then you have to have a look at every particular case, and only on that basis you may assess whether you are concerned by force majeure, whether you may refer to force majeure due to any difficulties you may have in relation to your agreement. In all jurisdictions which we have two things common. We always have a general force majeure clause in the law, which says that if there is force majeure, then you are not responsible for the non-performance of your agreement. The force majeure is defined in the law. It always says force majeure circumstances are extraordinary circumstances, are circumstances which are inevitable to the relevant party, always concerned regarding the concrete situations. There are exemptions made in the law. For example, says the law that the breach of an obligation of a contractual partner, of a subcontractor, is not force majeure. Lack of money and lack of goods to perform the obligations are also usually not recognized as force majeure circumstances. There's a second group of provisions. This is not force majeure, but they are called change of circumstances. That means that the parties have entered into an agreement, and later the circumstances on which they have trusted when entering an agreement have changed to the worse. And these change of circumstances are usually also, I would say, extraordinary circumstances which cannot be evaded and which cannot be coped by the parties. What is always and the consequence of this change of circumstances is that the relevant party may either cancel the agreement or may ask for an amendment. And usually this is to be done by bringing a lawsuit to the relevant court. What is also common in all jurisdictions is that the circumstances which are changed or which are force majeure must be unpredictable by the parties when they entered into the agreement. Kasadlna, what concerns coronavirus, it's, I think, very important to have in mind a timeline, how the circumstances with regard to coronavirus developed. So if you have entered into an agreement in 2019, you can be quite sure that this was happens now, could not be foreseen, it was not predictable. So that means if you entered into the agreement in December 2019, you now can refer to force majeure. If you entered into the agreement after March 2020, it's already a question, because there already were certain decrees which says that foreigners coming back to Russia, for example, have to go into 40 days self-isolation. There, it may be already said that yeah, maybe you could foresee something and it's no more unpredictable. But in any event, in Russia, from the moment when the this regime of alert was enacted, then if you're entering an agreement, you must say everything what happened is more or less predictable, so you have no further chance to refer to force majeure. And the same also now, when you're entering now into an agreement, you have to fulfill it. You know the circumstances, and if you enter an agreement, so do what you have promised. So that's what I wanted to say for general, which applies more or less to all jurisdictions. I would now give the word to my colleague Diana Mosifzian to describe the situation in Armenia.
Yeah, hello, can you hear me? Hello?
I can hear you.
Yeah, okay, fine. Let me check that all technical problems are solved. So, welcome, good afternoon. It's already afternoon in Yerevan. My name is Diana Movsesan. I'm head of Yerevan office of Schneider Group in Armenia. And I do really very much hope that our today's webinar will be useful for you. And to start with, let me share with you some thoughts and some ideas about it. To start with the situation in country, and as you can see, the situation is more or less the same in all countries that faced COVID-19 during this day, and state of emergency proclaimed in Republic until May 14th. Restrictions applied to the whole territory of the country. The right of free movement of citizens is restricted, and several types, almost all business activities are restricted, as it is impossible to conduct business operations in the country, save for several types of business operations. And to mitigate this negative consequences for the business, government currently implemented some support packages, almost 13 packages actually, to support the business activities and citizens that suffered from COVID-19. Well, several legislative amendments to some laws to make the life of shareholders easier were undertaken by the lawmakers, and I would like to especially mention the law on joint stock companies that was amended so as to allow the meetings of shareholders and general assemblies to be conducted in real mode. The law allowed to be conducted in real time and not to breach the deadline defined by the law for those shareholders, foreign shareholders, that are not able to come and participate in these meetings personally. So let us move next and to the next slide, and let me provide you with a brief approach and how the state bodies consider the situation with COVID. It is very interesting actually to see that the only state body, that is Public Services Regulatory Commission, that officially proclaimed situation with COVID as a force majeure. And it will last till the end of the state of emergency. What does it mean for operators of utility services? That means that they will not interrupt the supply of gas, water, and electricity, whereas the payments from the population for utility services shall be postponed. Actually, they will be paid, but they will be paid later on according to some specific schedules that will be defined for population. And currently it's clear actually that the cases related to COVID-19 and its treatment are yet to come, and thus we do not have the decision yet that could provide us with more or less useful guideline how to treat situation with COVID, whether it is force majeure or not. It's what's worth saying that decisions of the Supreme Court act as a persuasive precedent for the lower courts in Armenia when dealing with similar cases and circumstances. Thus, we're still expecting those situations and litigations, how the courts will solve this problem and how would Supreme Court refer to them. However, in past, we have several cases related to treatment of force majeure, and I think it would be interesting to present you its approach in past. Well, in the past, Supreme Court interpreted the respective provisions of the law of force majeure. Please note, we're not talking about cases related to COVID. It was just it were just some cases that were related to force majeure and its interpretation. And the issue in question were obligations and force majeure. Well, in the past, the position of the Supreme Court was that should be extraordinary and inevitable events that are insurmountable, objectively insurmountable. That is to say, the test applied by the Supreme Court for an event to be treated as force majeure, it should be objectively insurmountable. The circumstances, however, court's approach was that these circumstances should be treated, interpreted, evaluated on a case-by-case basis with reference to the nature of obligation in question, considering the whole context, scope, and the conditions of performance of obligations, and whether they are in reality objectively insurmountable. And a very interesting thing that there was an exception for a party in breach that was engaged in operation for profit, that is the commercial activity, and the burden of proof is on the party to breach the proof. He should prove impossibility of performance of obligations, that was because of force majeure. I have to say that force majeure is not applicable where under the contract or the law, the liability of the party for improper performance or non-performance of obligations is defined even during force majeure circumstances. That is to say, force majeure circumstance is not an excuse in these cases. Well, I think it was a theory, and let us move to practice. Actually, I think that it will be very interesting for you to consider some cases that I would like to present you, how we dealt with it, and what are the main challenges and issues businesses faced with. So in March, we faced a situation where due to state bodies act, namely a decree on limitation or suspension of a list of business activities, I told that before, a lot of companies, a lot of businesses had to restrict or to stop their business operations. Exception was done for the work from home. That is to say, where employees are able to organize the work remotely for whom they can organize it and they should pay for that accordingly. So the issue with the client that business operations of this client were closed and he objectively has no possibility to ensure work from home because there were some specifics of the work. And the question was, what are the obligations of the employee in this situation, namely whether he should pay for that, for objectively for the work that is not performed because of stop of business activities. And we refer to the respective clause of the employment contract. Actually, we studied it that was related to liability of the parties and namely the employee. Actually, we were having in aim to rely on force majeure regulations. And amongst those situations listed in contracts were earthquake, fire, war, declaration of state of emergency, martial law, political movements, termination of the means of communication work, governmental bodies act, etc., that made performance of the obligation under the contract impossible. We referred to the labor law regulations, namely the provision regulating a payment in force majeure situations. And it states that whenever the reason of non-payment is the force majeure, the employee is should not pay. Well, we move further, and in summary, we had a declaration of emergency case as a force majeure, the act of governmental body treated as force majeure in contract. We have legislative provisions about situation where the employee shall not pay. When combining and evaluating the interpretation of the Supreme Court on force majeure with respective provisions of the contract and the labor law, well, we come to the following recommendation. And the recommendation was the employee shall not pay for the cases mentioned above, provided that there is no objective possibility to issue work from home due to specifics of the work. I would like to invite your attention that all justifications related to objective or impossibility to issue the work, to organize the work from home were properly formalized, documented, and archived to ensure that employee is on the safe side. Well, the next case, which is actually very interesting, at least for me, there was a reaction on COVID restrictions and governmental actions. That was a case with international supply, and it was a contract on supply of equipment until March 13th. It was signed on February 1st. Equipment was on its way to Armenia with estimated arrival until March 20. On March 14, the Armenian-Georgian border, which is the main border of the country, was closed for 10 days. And exactly at that time, equipment arrived at the border. It was waiting for customs formalities to be finalized and formalized so that the goods will be released accordingly. However, due to restrictions, as I said, there was a closure of the border for 10 days. Significant outage in customs bodies works caused some delay in supply terms, but didn't prevent actually or made it completely impossible. And the supplier's concern was the breach of supply terms in contract and possible reliance on force majeure. Well, in other words, the supplier was treating the decree on closure as a force majeure event that makes performance of his obligations impossible or with breach. Well, we combine the respective provisions of supply contract on force majeure that states that the party shall be excluded from liability for failure to comply fully or partially with the contract if it was the result of an insurmountable force arising after the contract. As you can see, it was very close to the interpretation of the Supreme Court in past related to force majeure. It was an insurmountable force. Well, which the parties couldn't anticipate or prevent. Upon revision of the respective decree, it's very interesting. It didn't apply to logistic and cargo transportation. The restrictions applied only to citizens, free movement of citizens. And applying the interpretation of the Supreme Court on force majeure, that is some extraordinary, inevitable circumstances that are objectively insurmountable. Our recommendation was not to rely on force majeure, but to prolong the supply deadline under the contract for some period because of some difficulties and change of circumstances due to COVID-19. Since the mentioned decree and the state of emergency were not themselves were not the events that made the performance of obligations under the contract totally impossible. Instead, it was actually possible with probability of some delay. And advice was to agree with counterparty for a new deadline to prolong the deadline of supply. The counterparty agreed with deadline prolongation, and the respective amendment to the contract was signed between the parties. It's worth mentioning that the equipment has been supplied properly and without any breach of initial contractual terms. And well, we have come to the end actually of my presentation here. I prepared a memo for you. Should you face the problems due to COVID, hope it will help you to mitigate the consequences and treat the situation objectively to minimize the negative consequences of this event. Well, at first, what is recommended to do, review your contract with regards to force majeure clause availability therein and list least all obligations, you will not be able, or you think that you will not be able to perform due to COVID. Pay special attention to contracts governed by English law. Why? Probably it would be interesting to know that English law doesn't have a doctrine of force majeure itself. Instead, it deals with frustration of the contract. Thus, be ready to prove that the event in question was a reason for frustration. In case you have contracts that are governed by English law or your partners are from the UK jurisdiction. Inform your partners about difficulties. Actually, my position and my approach, my personal approach is always try to negotiate, always try to agree upon between your parties and come to a solution, rather than later on to go to court and try to prove, try to justify. At this stage, it would be the most wise solution to for your problems that you are currently facing with. So thus inform your partners about difficulties and inform them about possible deadlines in your performance. Propose to suspend the contractual obligations for some period, either terminate them or come to an agreement. And be ready to justify and satisfy the requirements for COVID and the force majeure test if you're going to rely on it. Be ready to collect as much proofs and justifications as you can in case you think you will not be able to perform your obligations. Just objectively deal with them and try to treat whether you are not able to perform them or you will perform them with delay. And amongst other proofs and justifications could be certificates provided by the Chamber of Commerce of the respective country. That could be decision of any governmental body, and in this case it was in Armenia it was the only body that stated that this was a force majeure. It was Public Services Regulatory Commission, etc. Everything that could help you to justify and satisfy the requirements of force majeure. And in summary, to sum up, I just would like to say that it's not enough that the contract just simply become more expensive or more difficult to perform. It's not a force majeure. Don't mix it up. There are still no 100% guarantees that you will be able, as a company, you will be able to rely on COVID as a force majeure event, provided that you satisfy all these requirements for the test for the event to be treated as force majeure. And following the listed points will help you to minimize your business risks, mitigate negative consequences, possible failure of business operations, as well as to justify arguments should the counterparty decide to go to the court. Well, that was it, and hope that will help you. Thank you very much. Stay healthy and safe, and with great pleasure, it's my pleasure to introduce you my colleague from the Ukraine, Mr. Artem Barinev, who will provide you with a very interesting presentation about situation in Ukraine. Thank you very much. Artem, the floor is yours.
Diana, thank you for this kind introduction. Dear participants, my name is Artem Barinov. I'm Associate Director on Legal and Tax Question at the Ukrainian office of Schneider Group. Please let me know if you can hear me well. Well, I'm opening my presentation. Okay, so I will share with you some experience from Ukraine, what is going on here with force majeure circumstances, because there are actually cases and examples which can be useful for business at the moment. So in the presentations, we'll focus on legal background of restrictions which can lead to force majeure and the current status of them, which we have in Ukraine. Then I will speak about application of force majeure clauses in practice, and I will share a short case study with you. So speaking of legal background, at the moment we have a decree of Cabinet of Ministers that stipulates nationwide quarantine at the territory of Ukraine. It should last until 24 4th of April. However, it was already announced that highly likely the quarantine will be prolonged until the 12th of May at least. And there are some possible reliefs in this regime, however, no information about that. And we also have a couple of new laws which introduce the changes to the current legislation and adapt it to the situations with force majeure, with restrictions and quarantine in the territory of Ukraine. These are the law 530 and 540. There is a summary of the main restrictions which are applied in Ukraine at the moment. So we have, as I said, nationwide quarantine. We have emergency situation regime in all the regions of Ukraine, which affects mainly the movement of transport. The mask regime, so-called, or using any other individual protection means, was announced in public places starting from the 6th of April. There is a ban on visiting public places, such as parks, squares, and so on. The exceptions are going outdoor with pets or some business needs which can be proved. There is also a ban on public events in the area of sport, culture, religion, and so on. And most of businesses which accept the activities which require accepting the visitors are blocked, and the exceptions are some critical infrastructure such as food shops, drug stores, petrol station, telecom stores, hospital, and so on. And these businesses are allowed to work under condition that they can ensure there is no more than 10 square meters of premises is used by one person, not less, I mean, because this is like social distance for visiting the places, which can create a crowd. On this basis, there are actually following provisions that affect the fulfillment of contractual obligations. So the main change which was introduced by the new legislation is adding the quarantine to the list of force majeure circumstances. Basically, so it should be said that the COVID-19 situation, it's not a force majeure by itself, at least according to the legislation. But the quarantine measures introduced by the special decision of the government were added to the law of Ukraine on trade and industry chambers. And this law allows now to certify the quarantine measures as a force majeure circumstance. And although the quarantine by itself has the criteria of force majeure, which Thomas mentioned in his introductory word, and potentially the counterpart to the agreement can prove that it is actually the force majeure. This change makes easier the negotiation between the parties, and it grants the possibility to rely on certificate from the Chamber of Trade and Industry, and this will surely helps to resolve any conflicts which can have place in fulfillment of agreements. In addition, there was a legislative provision that confirmed the position of the Civil Code of Ukraine, which grants a right to be released from the rental fee if the tenant cannot use the property due to the circumstances they cannot influence. So previously, this provision was present in the Civil Code, but the new law confirmed it once again that it can be used in the situation of quarantine restrictions, and this is also quite helpful for the businesses affected by these restrictions. In addition, the landlords which rent out the property, especially real estate, they were released from land and property tax to make them easier to provide some reductions or discounts to their tenants in terms of rental fee. So now we are going to speak about the practical applications of force majeure. So what are the characteristics that we have in Ukrainian legislation regarding this circumstance? So it makes the fulfillment of obligation impossible. It provides relief from liability for default of contractual obligation. So it doesn't mean that the obligation can be cancelled. So you should not mix these things. It only provides the relief from responsibility for default. And it can be confirmed by the authorized body that I said is a Chamber of Commerce and Trade in Ukraine. It should be said that the force majeure circumstances listed in the legislation is not exhaustive. And basically it is open, and the events which correspond to the criteria of force majeure can be also recognized as force majeure. Besides the events which Thomas already mentioned that are not force majeure, according to analysis of Ukrainian court practice, we can add also some of them, such as financial and economic crisis, national default, and fluctuation of national currency. What can be done if the business faces a situation of restrictions and there are criteria of force majeure situation? We advise strongly to inform the counterparty immediately when the situation takes place. It is also advisable to issue the order of the company on suspension of work or shutdown of activity due to force majeure circumstances, depending on how heavily the business is affected by the situation with restriction. And of course, it will be helpful to request a confirmation certificate from the Chamber of Commerce and Industry. But it should be noted as well that the requesting party has to prove the link between quarantine and inability to fulfill the obligation. There is also a position of Ukrainian courts which provides certain obligations for the parties who claim they are affected by force majeure and they would like to be released from the responsibility for default of their obligations. So such parties has to prove the following. At first, the very fact of force majeure circumstance, extraordinary nature of the circumstance, inability to prevent it, and the link between force majeure and damage which was caused by default of the contractual obligation. Now we are going to take a look at some case study. So just imagine the situation. There is a jewelry shop in Kyiv and it has been closed because of quarantine measure. Quite common situation. The jewelry shops are not listed in the list of exceptions of businesses that can work in the current circumstances. And of course, the shutdown caused some problems with liquidity, which make difficult to pay a rental fee for the premises. In this situation, there are quite important questions for the owner of this shop, and they are following. Is it possible to cancel the rental fee for the shutdown period due to force majeure? And is it possible to avoid penalties for untimely payment of the rental fee? So answering the question number one, as it was said, financial difficulties by itself do not lead to discharge from rental fee payment in such situation. So the party has to prove actually that the restrictions have led to the situation which caused the default of obligation, and just the financial difficulty is not that circumstance. However, it is also always advisable to have the negotiations with the landlord because it is clear that both parties to the rent agreement are counting on long-term cooperation, and everybody understands that restrictions are not permanent. They will be lifted at some time, and the parties are not interested to deteriorate relationships with each other. That is why under the mutual negotiation with the landlords, and there are cases in Ukraine when the major landlords of trade centers, shopping malls, have canceled the rental fees for the small for their clients, because they were actually closed, and the trade activity was blocked there. So, in our opinion, the mutual negotiation with your landlord can be a strong measure to reduce or cancel the rental fee for a certain period. And as I already said, there is a special provision on the non-possibilities to use the property due to circumstances that the party cannot influence. So in this case, you have to prove, the owner of this jewelry shop has to prove to the landlord that there is no possibility to use the premises, for example, due to the following events, such as the shopping mall was completely closed and there is no access to the premises, or there is a transport restrictions which make it not possible to get to the place where the premises are situated. So to sum up, the answer is on the question one, depends on the current circumstances, but there are quite good chances to succeed in negotiation with the landlord. Questions too about penalties. There are even more chances to succeed here, because the force majeure directly prescribes, the legislation provision prescribes that force majeure circumstances releases from the liability for obligation default. And in order to have this release, it is necessary to start official communication with the counterparty. There should be immediate notification about the situation, and the certificate from the trade and industry chamber can be a good tool to strengthen the position of the party in negotiations with the landlord if there is no mutual decision to cancel the penalties for untimely payment. So this is it from my side. I hope my presentation was useful for you, and if you have any questions, please write them down in our chat. I will be glad to answer them. And for the moment, I give a word to my colleague Victoria and Thomas as well to continue our webinar. Colleagues, the floor is yours.
Thank you, Artem, for introduction. I will start. My name is Victoria Sidova. I'm a senior legal expert of Schneider Group in Moscow office. And today our topic is, of course, force majeure. I will tell you about Russian jurisdiction. So just a moment, I open the correct slide. First of all, I would like to talk to you about one very interesting document. These are explanations which are prepared by the Supreme Court. This document is not published at the moment in Russia, but it is very important because it applies to all legislative acts which were adopted in Russia due to purpose to restrict spread of the coronavirus in Russia. So one of the hot topics which is considered by the Supreme Court in this document is terms, and especially work-free days. As you probably know, the President of Russia declared that the period from the 30th of March through 30th April are the so-called work-free days. But Russian legislation doesn't know. What does it mean? Shall these days be calculated by calculation of terms? Shall they be considered or no? In our situation, also some business activities were restricted in Moscow, and some organizations continue to work remotely. And that's why this question is really very important. Due to Russian civil code, as you probably know, if the term is calculated in days, and if last day of term falls on a non-business day, then the term expires on next business day. Sometimes also parties agree in their commercial contracts that the terms shall be calculated only in business days. In explanations of the Supreme Court, the court expressed his position that non-business days shall be not considered for calculation of contractual terms and also for limitation terms. Also, we found some other documents, for example, letter of the Finance Ministry of Russia, where the Finance Ministry emphasized that such work-free days, this period of time declared by the President of the Russian Federation, shall not be taken into account for calculation of processal terms for tax, for example, for office tax audit. Besides, there were also several informational letters of the Central Bank of Russia, where the Central Bank also expressed his position that work-free days do not apply for financial sector and for banks, and the banks shall continue providing their services, for example, processing of payments. The other question, which was covered by the explanations of the Supreme Court, is whether coronavirus can be considered as force majeure event. And the Supreme Court answered no. Coronavirus itself is not a force majeure circumstance, but every single case shall be analyzed, and on case-by-case basis the court will judged if the party can be relied from liability. So we see that the approach is really very much alike also, for example, to Ukraine. By analyzing the cases, the court shall consider the following facts: type of activity being subject of obligation, conditions for activity, in particular location, character and term of obligation, also how reasonable your partner was, and etc. For example, which circumstances can be possible grounds for force majeure event? If these circumstances are caused by coronavirus, or if they're caused by acts which were taken by state or municipal authorities. For example, if these acts restrict liberty of moving, or if your employees are obliged to self-isolation, in case they rule for behavior in the state of high alert and emergency situation. Some activities of businesses and organizations were prohibited for this period of time. All this shall be taken into account by court. As Thomas already mentioned, and I think Artyom also, lack of money is usually not ground for a force majeure event, but the Supreme Court expressed the position that in case a lack of money is caused by circumstances in connection with coronavirus, for example, prohibition of certain activities or obligation for self-isolation, then in this case, it can be considered as a ground for force majeure event. The Supreme Court also underlined that breach of obligations by subcontractors and lack of the goods in the market are still not good reasons to recognize the case as a force majeure. Besides, we also in Russia pay your attention that you shall behave reasonable in the current situation, and you shall show to your contractual partners that you took all reasonable actions to perform your obligation and to reduce all negative consequences of the coronavirus. Of course, please study your contracts, your contractual obligations, especially the articles about force majeure. Check how is regulated your obligation to notify your partner. Usually there is a special term which shall be followed. And please timely notify your partner. Otherwise, you shall be obliged to compensate for damages. As Thomas already mentioned, parties have not shall not have predicted the occurrence of force majeure circumstances. If, for example, now you consider to conclude a new agreement and you will try in the future to refer to coronavirus, to spread of coronavirus, or to some acts which restrict you to perform your obligations, I think you have no chances to prove that it was a force majeure event, because you could predict the situation. You are aware of this now. Sometimes when the partners are not able to perform their obligations in time, the contractual partner, the creditor, can lose his interest in performance of this obligation. And the Supreme Court also underlines that the creditor keeps his right to refuse, in this case, performance. Next part of my presentation, I would like to speak about also the situation in the market with lease agreements, with leased promises, and etc. And now I think the situation is similar in all the world, but now all shopping centers are closed, and a lot of business organizations in Moscow, for example, are not able to conduct their business activities. They have losses. And of course, there is a question, who shall pay? Sometimes the tenant is not able even to pay the rent because of these losses. And who shall bear the risks? Who shall compensate for this? There were some supporting measures which were introduced by Federal Law 98 and by the Government Decree 438, where the tenant received the right to demand rent payment deferral for a certain period of time. Terms are regulated by the government decree, but this concerns not all business organizations, but only those who are from industries mostly affected by coronavirus. And these industries are also determined in the government decree. For example, transport, culture, health, fitness, sports, tourism, hotel businesses, restaurants, cafes, and etc. Besides, due to the above-mentioned acts, the tenant is entitled not only to demand a deferral of the rent, but also rent decrease. In this case, lease agreement shall be concluded before introduction of the state of high alert, and of course, tenant shall be unable to use the rented premises. This might be difficult, but to prove for the tenant, because in some situations, landlord itself doesn't prohibit the tenant to enter the leased premises, and in some situations, even in place of the tenant, occasionally enter these premises from time to time. Anyhow, there are also some other instruments by the Russian Civil Code which can be used to demand rent decrease. For example, Article 614, due to which, if conditions of the use of premises has significantly deteriorated, you can demand a decrease of rent, but the tenant shall be not responsible for the reasons of the worsening of use. And material change of circumstances, which is regulated in the Russian Civil Code by Article 451, also gives this possibility to the tenant to demand rent decrease. and also to terminate the lease agreement. To use this article, you have to follow the same requirements as were stipulated to require demands that this is a force majeure event, but the legal consequences are quite different. As we think this is, of course, a good instrument, but let's see how it will work. The court practice earlier was not developed due to this article. The courts refused, but now, due to explanations also of the Supreme Court of Russia, we expect that the court practice will change, and probably even this instrument will work. Anyhow, I think that termination is often not in the interests of the tenant, and that's why we also recommend to negotiate with your contractual partners. I think this is all I would like to tell you in my part of presentation. And of course, I think that there are a lot of legislation acts, and these explanations which are prepared by the Supreme Court are very interesting and are very useful now. They will help the courts to make their judgments, to make their considerations if your particular case, for example, is a force majeure event or not. Now I would like to thank you for your attention, and to give my word further to Thomas, who will speak about practical advice, what you can do in this situation practically. Thank you.
Yeah, thank you very much, Victoria. Just to say some words, because I think we already have exceeded our time. What I think is very important in the given situations is already mentioned by Diana in particular, is of course keep reasonable, keep moderate, and keep in touch with your contractual partner. The current situation is difficult for everybody, so you have difficulties to deliver, you have difficulties to receive payments, your contractual partner has similar difficulties. So try to keep in touch with your partner and try to keep agreement with him, and if you are able already to know how things may develop, what could be done, enter into an agreement and try to adapt the agreement to the current circumstances. What is of course important, if you want to refer to force majeure, it is necessary to inform, to notify your contractual partner. If you do not notify in time, you may lose your right, or you may become subject to obligations for compensation for damages. What may be interesting for you is if you have a Russian subsidiary in Russia, and a foreign citizen is general director of your company, and this general director is not able to come to Russia, you should provide for a replacement. You should keep the company running. You should keep somebody in the company who's able to manage the business. So you should, if this is necessary, you may wish to appoint a second director who's able to conduct the business as long as the director is absent. When you're entering into new agreements, keep in mind the situation now is predictable. Now force majeure for new agreement is no, coronavirus in new agreements is no more a force majeure. It can be predicted, you know the situation. So if you want to enter an agreement, just make sure that you are able to deliver, that you are able to comply with your obligations. And what is also recommended, describe the situation in which you are, in which your contractual partner is, what you think may show up, which difficulties you may have, and how you intend to cope with the difficulties. That's, I think, 3 general recommendations which you can give. And then I want now to hand over to Azamat Gomalov of our Almaty office to describe the situation in Kazakhstan. Thank you.
Thomas, thank you for the introduction. Please let me know if you can hear me well. Hello, everyone, again. My name is Azamat Gumarov. I'm team leader of legal group in Schneider Group in Kazakhstan. And now I would like to speak about three main topics with regard to force majeure. First one is what is force majeure in Kazakhstan, regulation. Second part is government and courts. And the last part is actions to be taken with our recommendations. So definition of force majeure in Kazakhstan is quite similar to what was described in the aforementioned countries earlier, and it is extraordinary and inevitable circumstances that are not the fault of any party and that makes it impossible for the parties to properly perform obligations. And parties are exempted from responsibility for partial performance or complete non-performance or improper performance of their obligations. The main principles and criteria are emergency and inevitability of the force majeure circumstances. And the main principles are that event has already occurred and it is beyond control of the parties. It resulted in non-performance or improper performance of obligations, and the parties have taken all reasonable steps for a proper execution of their obligations. And as we can see, the definition of force majeure is quite similar. However, government resolutions and court regulations may differ. So by the decree of the Kazakhstan president, a state of emergency throughout the country was initially declared from March 16th until April 15th. And further, a couple of days ago, the state of emergency has been extended until the 1st May 2020. And throughout the country, right of free movement of people is restricted in the cities, and country borders are closed, and businesses in the larger cities are mostly closed. However, Kazakhstan anti-crisis package is targeted as well at easing the pain for businesses by providing cheaper loans and tax incentives and cutting back on audits and promoting employments. With regards to the courts, the following measures have been taken. Firstly, submission of claims to the courts has been postponed until the end of the state of emergency. Current court hearings have been brought online or postponed as well, and 70% of judges and court employees switched to remote working mode. Currently, there are no court decisions which have been taken with regard to the force majeure circumstances in Kazakhstan. However, further in these presentations, we will also discuss frequently asked questions. And now we go further to the actions which should be taken by the companies, by the businesses with regards to force majeure. So there are two main steps to address this circumstance. First steps consists of reviewing provisions of the agreement in order to see if they allowed application of force majeure circumstances. Then checking direct link between failure to properly perform an obligation and the effect of COVID-19. And the last one is listing obligations that resulted in failure to perform them due to COVID-19. And the second step is to notify the counterparty on the difficulties in performance of obligation, then propose to suspend performance of obligation that affected due to COVID-19 for a period of force majeure, and obtain the certificate confirming force majeure circumstances from the Chamber of Commerce of Kazakhstan. And now we go to the frequently asked questions. First question is, does COVID-19 automatically release a party from performance of obligation? And COVID-19, under the law of Kazakhstan, shall not be assumed as force majeure that automatically releases the party from obligation to properly fulfill performance under the concluded agreement. And actions which have been mentioned earlier in this presentation will help to minimize any business risks which connected to force majeure circumstance. And if the counterparty does not accept COVID-19 as force majeure, then the company should be prepared to justify such circumstances in the court. And the second question which we received from our clients was, what is the procedure for obtaining a certificate from the Kazakhstan Chamber of Commerce? First of all, Kazakhstan legislation requires, and it is mostly mentioned in the concluded agreements, that for the purposes of using force majeure circumstances, under the agreement, the party should obtain a certificate. Such certificate confirms circumstances of force majeure, and it is obtained in Kazakhstan Chamber of Commerce. This chamber considers application within 5 working days, and during the state of emergency in Kazakhstan, currently the chamber provides certificates free of charge. I hope that this presentation was useful for you, and in case of any questions, you shall be able to answer them at the end of our webinar. And now I give the word to my colleague from Belarus, Sergei Odintsov, who will describe the situation in his country.
Thank you, Azamat. Good afternoon, ladies and gentlemen. Can you hear me well? We will briefly describe the current status of affairs as concerns coronavirus and actions taken by the government in Belarus, what we have now. So, as already mentioned by colleagues for other jurisdictions, we definitely have the same meaning of force majeure, what is considered as a force majeure event here. So, and what I would like you to consider is that coronavirus is not recognized as a force majeure event in its nature by definite and precise measures taken by the government. And these measures should be restrictive. They can be recognized as a force majeure event. For instance, when the borders are closed, and when there is any prevention for business operations, when the party is not available to acquire, for instance, hard currency from the bank to perform, to make settlements under cross-border agreement, and so on. So it is worth mentioning that confirmation of force majeure event or force majeure circumstances does not release you from due performance of obligations taken under the agreement, but it does relieve from liability for non-performance of obligations, but only for the period when this force majeure event is happening. We would like also to mention that lack of current enforcement practice on the matter will be soon replaced by a Supreme Court resolution, and we expect this resolution to be in place very, very soon. So here you can see the status of measures currently introduced or going to be introduced by the government that would help us to manage the entire situation with coronavirus in the country, or would help the businesses and the citizens to deal with this case. You can see that Belarus, unlike its neighboring countries, has neither closed the borders nor proclaimed state of emergency yet. We have public places opened, all businesses, bank and financial institutions working, and however, there are some targeted restrictions that have yet been implemented or considered to be in effect very shortly. So you can see from this screen that we have 40-day self-isolation rule in place. We have also employees, and the employees are recommended to work in Minsk remotely. We already have rent holidays already implemented, and these are mainly applicable to tenants of state-owned real estate. And Belarusian government is currently considered to implement tax and loan holidays for the business. And we're expecting to have these documents in a couple of weeks. So Here you can see that overview of targeted restrictions that we currently have in Minsk. On 7th of April, there was a decision taken by the Minsk city administration on the matter. According to this decision, CEOs of local companies are required to deal with the following measures, to implement the measures within the companies. So these are as follows. Release employees with signs of disease from visiting offices, trying to hold all marketing and other events remotely, taking all measures provided by internet, so using video conferences means and other means, suspend of public presentations, exhibitions, and any other similar events, ensure safety and cleaning conditions, and many others. So speaking about fulfillment of contractual obligations in each particular case, we identified both cross-border and local transactions, which consequences of coronavirus might potentially affect on. Here you can see that supply of various goods, machinery, and equipment under cross-border agreements and making settlements on them might be potentially affected. Payments for leased real estate under local contracts, payments and delivery of food, catering, and entertainment services are also affected as well. Important matters to consider here is that you may raise a question: can my company rely on coronavirus as a force majeure event and thus be not subject to civil liability for undue performance of contractual undertakings? That is a good question, and current answer is not on the surface, as there is no current good practice on the matter in place in Belarus, and we strictly advise to review all transaction-related documentation and communication with your counterparty to justify and satisfy force majeure event before taking a final assessment. In case of any doubts, please consult your advisor or contact Schneider Group for assistance. We are definitely prepared to be your reliable partner in all jurisdictions of our presence. So here you can see that some tips that we would like you to amend the force majeure sections in the contracts. These are as follows. So please ensure that your contract has clear definition and description of force majeure circumstances, that the contract provides a detailed list of exit contractual obligations that may be impossible to fulfill due to coronavirus, that the contract provides for consequences in case of the other party failed to notify your party on existence of such force majeure circumstances, and there should be definitely a deadline for fulfillment of obligations after the force majeure stopped happening provided in the contract. And what else to consider is that we strictly advise you to follow the above mentioned approach due to the fact that Belarusian legislation and enforcement practice does not govern respective matters. Therefore, the more detailed case-related clause in the contract, the highest level of protection it provides you to the when your party is being relied on coronavirus at the force majeure test. So here comes the steps how to apply for a confirmation of the force majeure. So in Belarus, we have Belarusian Chamber of Commerce and Industry, BelCCI, that issues confirmations on force majeure circumstances. From general perspective, such confirmation is issued to companies being parties to cross-border agreement. If you have to apply this to local contract, then please consider amending this agreement before applying for the certificate. What else? In a nutshell, applying process is quite simple. What you need here to comply with is just to complete and file application and making scans of documents to confirm that you are under force majeure circumstances. And there is a specific email box of BelCCI to which you can send out all the documents together with the applications. and the authority, the BLCCI, will review all the documents and application within 15 business days and provides an answer. And you should pay for getting the certificates, a state fee, which is circa around $300 US. The significant point to consider here is that in the application, you should provide the evidence, or you should prove negative consequences of coronavirus and causal relationship of such consequences with you as a party, that you have inability to fulfill contractual undertakings in due term due to these particular circumstances. So here you can see recommendations to manage business continuity risk as a result of coronavirus. We developed these recommendations, and we really believe that these would help you to be prepared for the worst case scenario. For instance, when a counterparty will start an action against you for any breach of the contract due to COVID, trying to argue that you was under force majeure, but this event was not will not be treated as a force majeure because of the fact that current Belarusian legislation does not provide any clear guidance how to deal further, how the party should consider this event. So please consider amending agreements for coronavirus related provisions, and try to notify the business partner on any difficulties in due performance of the obligations. Assess and take all required measures to reduce potential losses in case of this event is happening, and try to gather evidences on force majeure, and that you really complete all other related actions. For instance, you took all measures trying to reduce losses to the counterparty. You notify the counterparty in a due course. What else to consider is that you should develop an action plan relating to each business transaction, each business relationship with a business partner, depending on the type of contract. And you should be prepared to justify and satisfy requirements for coronavirus under force majeure test if you are going to rely on it, definitely. So, colleagues, this is last but not least. It's definitely all from Belarusian side. And thank you for attention. And should you have any questions or concerns or comments, we can address them all right now, or you can send us an email, and we will be happy to review and respond accordingly. Thank you very much for attendance. So, and I'm giving the word to Thomas, I believe. Thanks.
Yeah, thank you very much, Sergey, for a description of the situation in Belarus. Yeah, my question to the auditorium: Are there any questions with regard to any of the jurisdictions? Please use the chat, write something down, or switch on your microphone and ask the question now. Currently, I have no question in the chat. So we are already here covering 5 jurisdictions. I see one is all is clear, thanks. Is this the situation for everybody? So unless maybe you have a certain contract, you want to raise a question. So I have one question: what is the price penalty for breaking in a rule? so that I can analyze if my gain is higher, e.g. government will close my business and I still perform till the police comes and shut down. I think this concerns Russia. I must say for myself, I do not have this prepared. Maybe Victoria, you can say something to this. If not, then I would say, Mr. Karstedt, that we answer this offline, because I have this not, to be honest, in my mind. But we are happy to send you an email and to give you some general information. Maybe even we have a newsletter prepared on this. So, Mr. Karstedt, I kindly want to ask you that we will come back to this after the seminar. So I have no more questions received. I see that the or many participants are logging out. So I want to thank you very much that you have attended our seminar. I hope very much that something was useful to you. If you have any questions, just do not hesitate to contact us. Mr. Karstedt, as I already mentioned, we will come back to you with answers to your questions. Thank you very much to you all, to the speakers and to the audience. Thank you very much and have a nice day and stay healthy. Goodbye.